Okay, Robert, first of all, how's everything going?
Good. So I got that camera that you have. So does it come across cleaner or not?
It actually does. It's sharp. Some people may not like the angle, but it is definitely sharp. It looks HD. It's beautiful.
That's good. So yeah, at least it's part of the way there.
And the audio is good as well. So this is I think my lighting is pretty good. Your lighting is good. Robert, okay. So first of all, there's a lot of new faces here, and I suspect it's because of the SDNY. Someone's honking outside. The SDNY's letter to the judge.
Maybe they're listening. How are you, SDNY?
So, if I may ask, and if you're not allowed to answer, are you involved in that file?
Not at this point, though the SDNY is motivating me to get involved in case that letter was meant to be a shot across the bow. I can't rule it past them. But no, not at this point, but may become so.
Okay, and now the context, and then I guess we'll start with this question before we get into the other stuff. SDNY is the Southern District of New York. What do we call it? Court district?
Well, it's literally essentially the federal court systems are divided between districts within states. So you have the Northern District of New York, the Eastern District of New York. Is there a Western District of New York? I think actually there is, and the Southern District of New York. So I think they have 4. Some states, California, you have Central, Southern, Northern, and Eastern. And so it varies by state. Some states only have 1 district, depending on like District of Montana, District of Nevada, things of that nature.
Okay, so the Southern Judicial District of New York, for anybody who doesn't know, now they're the ones prosecuting Kolfage and Bannon in the Go Fund the Wall alleged fraud. The indictment came out. I did a video breaking down the indictment. You did 45 minutes presenting the most compelling argument for why this is political prosecution, what the weaknesses are with the indictment. And then about a week later, the prosecutor, Audrey Strauss, writes a letter to the judge asking the judge to remind the parties at the upcoming hearing of Local Rule 23.1 about not discussing the case or making public statements that might compromise the case or taint the jury pool. So, first of all, you know what, Robert? Tilt your camera down more, because when I bring up super chats, it's going to cover your face otherwise.
Okay. Let's see. Does that do it? No. I probably go this route. How does that?
And then down. Okay, we'll live with it.
Yeah. What is I'm at maximum. Well, hold on a second. Is that better?
That's good. We'll live with it.
Yes, LV.
Okay, Rule 23.1, I read through it. Basically, it's is that what is typically referred to as the gag order? That's the authority under different jurisdictions that they will issue gag orders?
Yeah, kind of. I mean, in my view, it's preposterous to cite the local rule. It's the First Amendment and the Sixth Amendment that govern the matter. The case that they cite, Gentile v. State Bar of Nevada, makes that crystal clear. So citing the local rule is a joke. And in my view, it's sort of a mechanism or method by which they are avoiding the constitutional constraints on what they are attempting to do, which is to prevent a defendant from defending themselves in the court of public opinion and his counsel from defending him in the court of public opinion. And the facts of that they cite the Gentile case, but fail to even reference the First Amendment in their entire letter. That shows you the complete lack of respect the Southern District of New York has for everybody's constitutional rights. In my view, that they've proven that over many years to demonstrate that and exhibit that. And they fail to cite the facts of Gentile, which basically refute the claims they're making in that letter. They say Gentile stands for this proposition. No, it doesn't. It actually rebuts their claim. Gentile doesn't say, we're deeply, deeply worried about defendants or defense lawyers defending themselves in public in such a way that will make a fair jury trial impossible. That it says really quite the contrary. To give people an idea of the background of the case cited by the New York prosecutors, but failed to go into detail or quote from, and there's a reason for that. The reason is that it would rebut the entire premise of their suggestion, which is what they're doing is misusing and abusing the power of their office, as they have throughout this case to date, in terms of assets that they've frozen that they shouldn't have, bringing the case in the Southern District of New York where it has no business being in the first place, these other constitutional infringements they've already perpetrated at an early stage of the case. I'm sure there have been more rights violated given the nature of these prosecutors and their behavior to date. But is that the Gentile v. State Bar of Nevada, that's where the case originated, a defense lawyer orchestrated a press conference, and the nature of that press conference was to attack the prosecution, attack the police, in a case that was months away from going to trial in Nevada. And what the defense lawyer came out and said is he basically accused the prosecutors of suborning perjury, accused the police officers of being corrupt, of committing perjury, of framing people, things of that nature, accusations that have not been thrown at the Southern District of New York. Far less has been said at the Southern District of New York. And what happened was after the proceedings, the State Bar of Nevada tried to punish that criminal defense lawyer, citing a rule a lot like Local Rule 23.1 in the Federal Court of New York, Southern District of New York. And the U.S. Supreme Court said that the attempts to punish that criminal defense lawyer were a patent violation of the constitutional rights of the defendant and the speech rights of the lawyer as well. And what they made the point of is that you have a complete right to defend yourself in the court of public opinion. A competent defense lawyer has an ethical and professional obligation to defend you in the court of public opinion. And that there needs to be, here's what you're not allowed to do. Leak sensitive information that is not going to be admitted at trial right on the eve of a criminal trial in such a way that it is literally impossible to find 12 jurors who don't know about it and can't see past it for the purposes of their criminal case. In the post-Enron environment, where the U.S. Supreme Court said it was okay to try Jeff Skilling in Houston, despite one of the most contaminated jury pools in American history, I frankly don't see how any court can make that factual finding that any lawyer's conduct could even do that. Because if you can find 12 honest jurors despite the massively contaminated jury pool of Houston, then I guarantee you can find 12 honest jurors in the Southern District of New York, even if these statements had been made by the defendant and were on the line of Gentile, not the far lesser statements made that they were whining about here. And there was no chance that Kolfage's defense, and I don't and won't be representing him, there's no evidence that his defense had any high likely impact of preventing 12 honest jurors from being impaneled a year or years from now in Manhattan. So even assume it shouldn't be in Manhattan anyway. And to give an example, it's amazing how the prosecutors sort of undermined or limited what they themselves had done to already contaminate the jury pool in New York. What the prosecutors did is release the indictment and push it out and propagate it to every media source in New York. So for them to say, oh, we just issued a little press release. You forgot to mention that you included the indictment with that press release. Folks didn't have to go look it up. It was disclosed, and the nature of that, and by citing the indictment, either referencing it or including it, whichever they may have done to different press outlets, the news coverage was saturated nationwide and in New York in such a way that all that Kolfage could do at this point is try to limit the damage already done by the Southern District of New York, because the allegations of the indictment are inflammatory by nature. And the prosecutors always say, well, but we always put at the bottom of the press release, someone is presumed innocent until convicted. Yeah, like that takes away the damage done. I mean, what a crock. They know that's a bunch of nonsense. So there's no scenario in which anything Kolfage did could, in fact, be considered sufficient or adequate to mitigate the damage already caused by the Southern District of New York in a way that could erase that. All he could do is try to limit some of the damage, even if his target audience was that, and there's no evidence that was his target audience. They're like, oh, he has 600,000 followers on Facebook, probably maybe a few hundred of whom are inside the Southern District of New York. There are hundreds of thousands of people in the Southern District of New York. There's probably 99% of the potential jury pool who does not follow or know anything about Brian Kolfage. And if they've heard anything, it will be what the prosecutors have alleged is the case in the indictment against him. So the constitutional limit on gag orders, and this is why they're not requesting a gag order. The way prosecutors try to sneaky and corruptly get a judge going down this path to try to silence and suppress and censor speech by a defendant or a defense lawyer, or those who simply have an opinion on the matter, is to say, well, there's this local rule that says you shouldn't do anything that could possibly contaminate the jury pool, forgetting to note that has to be interpreted in a manner consistent with the Constitution. And they get the judge assigned this case, a very young judge, an Obama appointee. This is what they did in the Roger Stone case. Federal prosecutors did in that case, what they did in some of the predecessor cases. They said, whoa, we're worried about this rule and making sure it's complied with. No, what they're worried about is having their corruption publicly exposed. That's what happened in the Roger Stone case, where the reason why a bad juror and a partial prejudicial juror got onto the jury pool and was the foreperson ultimately of that jury is because the public was kept in the dark about that juror's bias, so that the public could not crowdsource research on that juror that would have exposed that juror's bias within hours. And so the only reason why that happened, the corruption of our criminal justice process, happened because of an unconstitutional gag order issued by the judge who had no respect for the Constitution that was presiding over the Roger Stone case. And they're trying to do the same thing here. And they're not only trying to do that. I mean, my view it's for them to put our photo on the front of it. And my photo inside the letter I took as a shot across the bow in case someone reached out to me and wanted me to get involved in the case. Just in case that was the objective, it will not work to their benefit because I don't take kindly to attempts by prosecutors to intimidate defendants and defense counsel of asserting their constitutional rights and remedies, particularly not from a division of our federal government as badly corrupt as the Southern District of New York. So I'm going to be increasing my public discussion of whether I am involved or not involved in the case. My commentary and criticism is going to go up, not decline, based on their attempts to muzzle the First and Fourth and Fifth and Sixth Amendment rights of criminal defendants by preventing their ability to defend themselves in the court of public opinion and expose potential misconduct and malfeasance in this particular prosecution, but one that is rampant in the Southern District of New York.
So now I just want to understand the basics of these. The gag orders, are gag orders different than these types of local rules, or are they based on it, or are they separate orders from the judge?
So gag orders have to comply with the Constitution. So these local rules don't mean anything. And generally, the local rule simply codifies what the Constitution compels. And it's better to read the court case and the legal precedents to understand this than to read the rule, because the rule is very generic. So these rules tend to be vague. There have been challenges. I've probably fought this issue as much as anybody. I fought on behalf of a civil rights lawyer in Wisconsin this exact issue about a few months ago, where they were trying to silence him. Why? Because he was exposing corruption in the Milwaukee County jails, corruption in aspects of the Wisconsin criminal justice process at the state level. And I had to remind that court of the constitutional constraints on any attempts to punish him for his speech or censor him for his speech or limit his speech. The standard is really, really high. In other words, it has to be a very high probability that your statement is going to irredeemably prejudice the jury. So the most criminal defense lawyers and defendants that are defending themselves are not focused on the jury at all. They're not trying to influence the jury. To the degree that there is any effort to influence the jury, they're trying to counterbalance false stories in the press about them that the jury may have read or seen. But in this case, clearly he's defending himself to his own audience. His reputation has been tarnished. It's been attacked. It's been dragged through the mud. His career might be crushed and ended because of what took place here. And just the indictment. Doesn't matter if he gets acquitted 2 years from now. Is anybody going to remember? Not likely. So he'll be forever, and every defendant accused will be forever tarnished by the nature of this indictment. The same is true of Rittenhouse, who there'll be people who believe he's a white supremacist, white nationalist, militia member who went up to kill people, even though the facts refute that entirely because of the media's accusations against him and because the also hopelessly dim-witted Kenosha prosecution decided to go forward in the case. So it is critical at times like these that high-profile political cases get the review and the attention of the public, because it's the only thing, in my experience, that truly has a history of successfully correcting and remedying and exposing corruption in our prosecutorial processes. And they have an Obama appointee, and so that may be motivating them in the same way the Roger Stone prosecutors, when you have some of these young judges who don't understand the full scope of it. I've been constantly shocked by running into judges who don't understand the limits on gag orders. They just think, oh, I can do this. And no, you can't. This is subject to the First Amendment, Fourth, Fifth, and Sixth Amendment, depending, which can be applicable in different contexts. You don't get to silence people. You don't get to gag people. You don't get to cover up corruption in the prosecutorial process. Just because our federal judiciary has done a lousy job policing corrupt prosecutors doesn't mean you get to hide that fact from the world. So there needs to be more criticism. There needs to be more observation, more public discussion. And there's plenty of ways to make sure you get an impartial jury. You can do written jury questionnaires. You can go through a detailed voir dire process. If it was good enough for the Enron defendants, if that was good enough for them, then by golly, it's good enough for everybody. And that means that a searching voir dire can suffice. Now, sometimes maybe a venue transfer has to happen, things like that. But all of those are the preferred remedy. The preferred remedy is not to suppress the ability of a defendant to defend himself in the court of public opinion when his freedom is on the line. And by the way, I looked at the sentencing exposure. You're looking at 8 to 10 years for each of these defendants. People don't fully appreciate that. They'll serve twice as long as a typical rapist if convicted. That's the kind of risk they're putting these people under, given the way the guidelines can be interpreted in cases like these. And I found it very disturbing that the Southern District of New York was taking this path. And I know for a lot of defendants, it would scare and terrify them into never asserting their rights. It would scare and intimidate a lot of defense counsel into not asserting their rights. And for it's not a surprise they're attacking me. But it's if they'd studied my history, that path is not going to work. So
Now, a lot of people were saying, I read the rules, that it only applies to the prosecution and not to the defense, which is not true. The way it's drafted speaks of the defendant's attorneys, and I'm fairly certain the wording of it also includes the defendant. But most people interpret it to say that the rules should be set up in order to ensure that the defendant gets a fair trial, so that it protects the defendant, but not against the defendant if the defendant wants to talk.
Yeah, and they try to put some presumptions in there about things like that. Those are constitutionally questionable. They were challenged by the criminal defense bar in Chicago when they tried the same thing in Chicago maybe about 20 years ago even. So this has been an ongoing fight. And the Supreme Court has never greenlit that rule being applied in such a way that would contramand the dictates of the Constitution. And the Gentile case is the best case for that. And it's the best example. If a defense lawyer can deliberately call a press conference in the community where the jury is within months of a jury trial being held and accuse the prosecution of actual crimes, accuse the police of actual crimes, of saying his client is a fall guy, and all of that is constitutionally protected and cannot be prohibited, that gives you an idea of the scope of it. That means nothing Kolfage did even comes close to that, and that is all completely constitutionally protected. So the Southern District of New York didn't talk about the facts of Gentile or the case and it shows how corrupt they are. If what they're doing is so honest, what they're doing is so honorable, you would welcome public scrutiny. You would welcome public discussion to vindicate the sincerity and the integrity of your operation. Instead, you're panicking about a YouTube show and a lawyer just pointing out potential issues, and you're screaming, don't let anybody share this on social media, Judge. Threaten the defendant and tell him what bad things might be coming if he does anything like this in the future. This shows they're corrupt. No reason for an innocent person to squeal like a pig unless they've been stuck with the facts of their corruption. So that's my view on it.
And not only that, but apparently at the same time that they're writing this letter to the judge, who is it? Not the inspector general, the postal inspector. What's the name of the person who's doing the investigation?
Yeah, it's on behalf of the United States Postal Service. They have a criminal investigative division, or a division that assists with criminal investigations when those concern mail fraud or wire fraud.
So at the same time, they have the postal inspector, I think was the word now, referring to the defendants as fraudsters, saying this should serve as a warning to other fraudsters. So the same time, they're simultaneously trying to silence the defendants via this questionable provision of local rules that restrict what they can and cannot say. At the very same time, they are alluding to the fact that they are in fact convicted fraudsters that should serve as a warning to others.
No doubt. They also leaked where they arrested Steve Bannon. Right. That has led to a wide degree of misunderstanding of what happened. Steve Bannon is assisting a Chinese dissident, not a Chinese spy, not a member of the Chinese government, a Chinese dissident, a very well-known Chinese dissident who wants to undermine the power of the Chinese Communist Party. And that's why they're aligned in that respect. And it wasn't Steve Bannon's boat. It's that guy's boat. So that guy's very well off. But this has not been secret information. That's been public. But they create the impression that they arrested him on a yacht. Maybe it's his yacht. Maybe he's involved with Chinese spies. They allowed these false narratives to get circulated by the selective rendition of the stories they leaked. They could have done an honest indictment. They could have included a whole bunch of facts, including exculpatory facts. They chose not to. So that was their choice. That was their course of conduct. That was their action. And you're allowed to meet it and contest it in the court of public opinion. That's what the Constitution affords you, as well as meet it in the court of law in front of a jury and a judge. And so attempts to suppress it and censor, this is becoming more commonplace. There's more and more corrupt government actors I'm seeing in more and more cases. They came after me in the Alex Jones case when I represented Alex Jones for a period of time in one of the Sandy Hook cases. They came after me for my public statements in his defense, try to get me kicked out of the case because of my public statements in at his behest. So it's done in such a way to basically try to discourage and deter lawyers from taking on these kind of cases. That if you or publicly speaking out, if you do so, we're going to come for you personally. We're going to come for you professionally. I was subject to a wide-scale smear campaign by aspects of the press related to that case. Same thing happened after Covington. So in representing the Covington kids. So it's an unfortunate dynamic, but it's a disturbing one that attempts to weaponize whatever access they have to the legal system or to the press to do personal damage to those who defend individuals that they don't like for political and ideological reasons.
Okay, and very interesting. Just to let everyone know, I'm taking screenshots or pictures of the super chats, and I'm going to get them, but they're blocking Robert, and I don't want to block him while he's talking. For people who don't know, Bannon, I was supposed to ask you this last week, was arrested on a yacht. So did they intercept the yacht? Did they get out on the water? Was the yacht docked? Like, how did it go down?
The boat is anchored. So, he was going back and forth and just happened to meet his client. The fact that they chose that day, the day that he happened to be out there, rather than just, they could have just issued a summons and he showed up. There was no need for a dramatic physical arrest. That was purely done for PR purposes, in my view.
Okay. And so they arrest him on a yacht. I heard this. I didn't know this at the time. It's not his yacht. So it's his client's yacht. Nobody really knows that. They go again with the sort of Roger Stone type arrest where they don't necessarily need to, given the charges, and create an impression with the public.
That's exactly right. And so and they often do that. They often, this was meant to be shock and awe. Also, the timing of it, they do it 1 week before the Republican convention. Nobody's going to convince me that that's all sincere motives. I suspect that the evidence will ultimately show that they seized a bunch of money and assets that are far in excess of what they even allege was fraudulently taken. I do think they are not going to use, they were real sensitive clearly to the statements that I raised about whether they were going to misuse their access to information about the so-called victims who are themselves saying that they're not victims, the donors to build a wall. And the fact that they are so easily provoked that they're demanding everybody not talk about this now and take a side shot at me from afar makes me think there's more there. There's no reason to get so defensive and get so. This is using their own logic. Their logic is if people use encrypted technology, that means they must have been trying to hide something. If people try to correct and fix something, it must be guilty. Well, for them to put out this notice must mean the Southern District of New York is guilty of bad stuff. And sooner or later, it's going to be exposed. Whether I'm in the case or not in the case, I will do whatever I can to expose the bad deeds of the Southern District of New York now that they decide to take this path.
And it's an interesting thing. People have to appreciate this. Once you appreciate the concept of projection, you know how to read what other people are doing when they do something, and you know that you can deduce certain suspicions. And it's an amazing insight, Robert. Now, and in fairness, the letter only asks the judge to remind the parties. So totally on top of it all, they're not seeking anything yet, but they reserve the right to do so.
If they had tried to, they knew that would focus the judge on the constitutional standards and it would get struck down right away. And so that's why they want to get a mindset going. Let's see how much intimidation we can get away with without ever anyone paying attention to the constitutional constraints on the court's conduct. You have a right to defend yourself in the court of public opinion. I mean, they tried to do this to Trump at different times, not the Southern District of New York, but other people in the political process and in the so-called legal process would attack Trump if he ever questioned anybody or pushed back on anything. They would call it obstruction of justice and this other ludicrous nonsense. It's like, no, that's your First Amendment right. That's your Fifth and Sixth Amendment right to defend yourself. Just because the government accuses you of something doesn't mean you lose your First Amendment. Doesn't mean you, in fact, now more than ever, you have a right to exercise that First Amendment to defend yourself in the court of public opinion. You have to. Otherwise, the effect of the indictment will be to secure your conviction in the court of public opinion in ways that will destroy you personally, professionally, and otherwise, even if no court of jury or no court of law concludes that you did anything wrong.
Fantastic. Okay, I think we've covered the Bannon and the Kolfage. There's no real news to report yet, as other than that letter, and we'll see what involvement, if any, you end up having. And it's an amazing thing because someone accused me of having been too easily swayed by your analysis of the indictment. And I said, I'm not swayed by your analysis. I think there's more things at play here, but it definitely is eye-opening. Both what's in the indictment, what's not in the indictment, and what they've done subsequent to what you said last week. It certainly gives a little more credence to everything you said last week as to how they responded, rather out of the blue. And I mean, I've seen Kolfage's his Facebook or Instagram, his social media posts. They're not crazy. There's no threats. There's nothing. He's complaining. He's angry, and it's outlandish to me that anyone could even think of saying you cannot. When you get accused, you get indicted, and you're forbidden from speaking of it publicly while it's pending. Well, that just makes you a punching bag for the next 2 years.
Exactly
what they're doing.
The Man in the Iron Mask is a character for a book. It is not a reality the Southern District of New York gets to impose on those they accuse. And so, but hey, you're famous. You're now in the Southern District of New York. You're part of the official court file forever. Will be the smiling face of Viva Fry.
Okay, before we move into the next topic, it's going to be the Hatch Act. Then we're going to do Kyle. Let me just read as many of these super chats as I can bring up. Absolutely. I don't think I can bring them up back in the chat, but
no problem.
Modem Insane says, what does the freedom of the press legally mean? From my perspective, they've done more harm than any politician has done over the past 4 years. How can we hold them accountable for their gaslighting? That's a $50 super chat. Thank you very much.
Good, bad, and otherwise, we have a free press, and they're allowed to have whatever opinion they want. If they make a false statement of fact about someone, then you can bring a libel or defamation claim against you. The only person who's not permitted to have an opinion is Alex Jones. He apparently, according to the Texas Court of Appeals in Austin, can be sued for defamation for things that are constitutionally protected for everyone else in America. But aside from that case, we rightly protect opinions, and we take as a sacrifice the fact that people might have bad opinions or opinions we disagree with as the price to be paid to maintain a complete free press. There's no question that the institutional press is misusing and abusing its disproportionate power. The problem isn't the press giving an opinion that's untrue. The problem is the press has disproportionate power to spread that opinion compared to everyone else. And that disparity of power when they misuse and abuse it to actually defame someone is a big reason why I took the case for the Covington kids, not Nicholas Sandman, but other kids who wanted to stay anonymous, 8 of them. There was about a dozen potentially involved, but 8 who've decided to file suit because I wanted to try to balance out the playing field to equalize the equation. The old TV show The Equalizer, which I was very popular of before it became a very good movie series with Denzel Washington, was a great TV series. I grew up on it as a kid, sort of my icon, if you will. If I were to define my legal practice, it's what I live up to try to do.
Very
and
cool.
So but yeah, so that's a short answer.
All right, we got Shabs R says, have learned so much from you both, Robert. Have learned so much from you and Robert. Thank you both. I can't bring it up, and it's a $49 super chat. Thank you very much. We got Little Rock, which I can bring up because it's still on my screen. Sorry, it's covering you, Robert. I remember from law school. I remember from law school, inciting violence is not covered under free speech. Can the MSM be charged for inciting violence with rhetoric about the MAGA hat now being the white S word symbol and reporting on riots and looting out of my wheelhouse?
The inciting violence has to be imminent and has to be specific. So give you an example, the Brandenburg case, Klan, threatened violence against African Americans in the neighborhood. U.S. Supreme Court said that is constitutionally protected because it wasn't imminent violence, imminent incitement of imminent violence against a specified person. Effectively. So it needs to have an imminent standard. The same is, it's called the true threat jurisprudence. And that's good. Again, unless you're Alex Jones and all of a sudden all the rules go out the door and all of a sudden you can be held liable for everything. If there's no question that if the media was held to Alex Jones's standard, the entire media would be out of business and could be sued into oblivion tomorrow. But I don't expect the courts to apply that to them, and I don't think they should. I think that's an incorrect legal standard they're trying to impose on Alex Jones. Constitutionally, we want to protect that. We want to make sure it's true imminent incitement and an actual true threat. I plan to cause harm to that person. Otherwise, they start to broaden language in such a way that constitutionally protected opinions become criminally punished, and we don't want that to occur. So I always take the side of free speech if there's anything close to it, and that's where I think generally the press is protected in that respect. If they specifically lie about an individual, then that can be actionable. But otherwise, the way to deal with the press is to counter it with truth in as many forums as you possibly can, and try to discredit the institution of the press. The best way to answer the darkness of lies is the light of truth, and that's still true. And that's the best way to answer it, not with the state getting involved in suppressing it, censoring it, or punishing it.